my honor today to introduce to you Heidi Epstein. Heidi is the Director of Kinship Policy and the Assistant Director of State Projects at the American Bar Association's Center on Children and the Law in Washington, D.C. In her role as Director of Kinship Policy, Heidi helped develop and currently manages the Grand Family State Law and Policy Resource Center in partnership with Casey Family Programs and Generations United. As Assistant Director of State Projects, Heidi co-manages the award-winning Permanency Barriers Project in various states, where she provides technical assistance, legal training, and statewide child welfare training to judges, attorneys, caseworkers, and service providers. She presents at conferences on various legal issues related to kinship care and permanency nationally. Prior to her work in the ABA, Heidi was a law guardian for Legal Aid of Maryland and a residential social worker for female juvenile offenders in upstate New York. Please welcome Heidi Epstein.
Thank you. I seem to have some competition going on over here, so if you can't hear me, let me know. Okay, so welcome. Thank you for coming to this session. First of all, I want to make sure everybody has a handout. There's a stapled outline. If you don't, there are some at the end of the table. Okay, what the outline is going to follow the PowerPoint. Okay, exactly, slide for slide. It's just less trees die if you put it in outline form than if you copy the entire PowerPoint. And I know that you also have the PowerPoint on your flash drive that you got for the conference, as well as some other material that goes along with it. But for today's purposes, you should be fine with just the outline. As Nathan said, I am with the American Bar Association's Center on Children and Law as the Director of Kinship Policy, and I work together with Generations United and Casey Family Programs to head up the Grand Family State Law and Policy Resource Center, also known as grandfamilies.org. Just out of curiosity, how many of you have ever visited the website grandfamilies.org? One person. Okay, well, you know what? That's one more than the last place I spoke, so that's okay. If you're interested and you want to know more about the website, and I'm going to kind of talk about it a little bit as we go through the presentation, there's a flyer up here that tells you about it. But basically, what we do is we compile kinship policies and laws and some legal analysis about kinship policy throughout the country, all in one website. So if you look up Nebraska, you'll see some of your policies and laws on that website on various kinship policies. Or if you're curious what other states are doing, you can go to that website as well, or to see sort of an overview of different legal topics related to kinship care. So the other thing that I wanted to let you know about is we do have the ABA every 2 years throws an annual biannual conference, and we have our biannual conference next July. If anybody wants to come to Washington, I was fortunate enough to get to come to Nebraska, which I've never done before, so it looks like a beautiful state from what I've seen. But if you're interested, there are some cards up here about the conference. So, can everybody hear me okay? Great, excellent. Please ask questions as we go along. There's a lot of material. We may not go through it all, but if I just stand up here talking at you the entire time, it gets a little boring. So feel free. I don't like to do questions at the end. I'd much rather have a good discussion about this topic as we go along. So feel free, raise your hand, and we'll have questions throughout. Okay? And I will see if we can go quickly. I'm originally from New York State, so I tend to get a lot of, okay, slow down, you're talking too fast. But we do just have an hour and a lot of material to cover, so I am going to go through some of it relatively quickly. You don't need me to read my PowerPoint to you. You've got it in an outline form, so we're just going to kind of go through it relatively quickly and hopefully have a good discussion about the topic. How many of you are familiar with Fostering Connections legislation that passed in 2008? Okay, a greater show of hands, that's good, that's excellent. In child welfare, we have a joke that everything is new legislation until something else comes along. So ASFA was new for 10 years, and now Fostering Connections passed in 2008. It'll be new for probably at least another 10 years, so we still call it new legislation. Today we're going to talk about an overview of kinship care. We're going to look at the laws and policies that support family engagement, give you sort of a legal framework of what the laws look like federal, but most specifically in Nebraska. We're going to talk about why it's important and how to engage parents and relatives, and then we're going to talk about some resources. Okay. So looking at the numbers, 7.8 million children in the United States live with relatives currently, according to the census. And that some of those are with parents in the home, sort of multi-generational homes, and some are without the parent in the home. Of the 7.8, 2.5 million have no parent in the home. They're being cared for just by the relatives. Out of that large number, surprisingly enough, a vast majority of them, only 1 out of 18, are actually in foster care. Most of them are in what we call informal care with the relative. Mom comes, drops off the child, says, I'll be back in a day, and then 2 years later, the child's still there. That's informal care. Okay, so we're going to talk a little bit about that as well. But predominantly today, we're going to talk about that smaller population that is in the foster care system. Basic show of hands. How many judges in the room? Okay, I've got a few. Great. How many attorneys? A few more. How many DHHS personnel, staff, etc.? Great. CASA? Excellent. Social workers that I did not name in another organization. Good. All right. Anybody I'm missing? Shout it out. Any other group that I'm missing? Okay. Foster Adopted Parent Association. Great. Excellent. I'm sorry. Family advocates. Okay. Excellent. Anything else? Probation. Good. All right. So we really do have a good multidisciplinary group. That's great. As you heard in my bio, I was a residential social worker, which I always joke sent me screaming off to law school. I have a tremendous amount of respect for those of you who do direct service with families. I then went on to become a law guardian, and now I'm working primarily in policy. But every day I get phone calls and emails from caregivers around the country saying, for example, my grandchild is in foster care, I want to care for them, they're not letting me. Those kinds of things. So we deal with all kinds of issues having to do with kinship care. Okay, so number-wise, 6.2% of children under the age of 18 in Nebraska live in homes that are headed by grandparents or other relatives, which is a fairly significant amount of children in your state. Okay, so kinship care. Before you kind of launch into the law, you have to make sure we're all on the same page. And the page that you need to be on is the fact that children fare better with relatives. They do better in homes of relatives than they do in homes of foster parents that they didn't know prior to coming into the system. What we have found is that children who live with relatives have more stability in their placements. They tend not to move around as much because grandma, aunt, uncle is more willing to put up with them when there's a problem instead of calling and saying, get this child out of the home. Not that they don't do that, they do that as well, but we find that they're more likely to stick it out through the tough parts with the relatives. We know that for safety and stability and well-being, being in the same placement is really what we want for the children. We want the first placement that the child to be their only placement, if possible. We know it reduces trauma for the child if they're being removed from the parent to go live with somebody they know, somebody they already have a relationship with. It reinforces their sense of identity. They get to stay connected with family, culture, religion, etc. Most of those things are preserved when they are placed with a relative. We also find that they tend to exit to permanency quicker when they're with a relative, depending on the structure in the state. And Nebraska does have subsidized guardianship, which we're going to talk about as one way to exit the foster care system and achieve permanency for children. And we know it can also reduce racial disproportionality when children and minorities come in at a larger number. General challenges of kinship care. There are a lot of challenges. When I speak to different groups about kinship care, I get a lot of, relatives shouldn't get paid, they should just be taking care of the children. Relatives knew that this abuse or neglect was going on. How can they provide a better home? They didn't protect the child before. The apple doesn't fall far from the tree. So some of those concepts and notions are the same and continue and constantly are a barrier to placing children with relatives. Another problem of placing children with relatives is if the policy and the structure within the agency is not established in a way that it's an incentive to place with relatives. I get a lot of, it's actually harder to place with relatives. We need to get them licensed, we need to do all this stuff. Whereas, here's a child, needs a home, here's a foster home. I've got a body, I've got a bed, here you go, a perfect fit. Not necessarily. So there are a lot of different things that you grapple with when you try to look at why children are or are not placed with relatives. You're looking at complicated family relationships. Perhaps an aunt steps forward and wants to take care of the child, and the mother says, no, I don't want my child with my sister. She's wanted to get my child from me all along. So we're looking at more complicated situation when you're talking about placing with a relative. You have to look at the training and licensing requirements and sort of balance, I have a relative who wants to care for the child. Are they appropriate? Are they safe? And finally, will they pass the licensing requirements by the state? And that's not always an easy thing as well. For relatives who are taking care of children outside the system, there is a lack of resources. There's a lack of supports for that vast majority of relatives care for children outside the system. A lot of caregivers don't want to deal with the system. They're afraid of the system. They say, if I call and say I have my grandchild and I need support or I need help or I think I need her to be in the foster care system for me to take care of her, they're afraid that the child's going to be removed. So there is an innate fear of working with systems and working with child welfare, working with the courts. However, if they do not have a legal relationship with that caregiver and it's just that mom dropped them off and they haven't gone to court and obtained any kind of custody or guardianship, they run into a lot of problems. Sometimes they can't enroll the child in school. Sometimes they can't get medical care for the child, get their records. There are a lot of problems if there is no established legal relationship between the caregiver and the children. And the vast majority of those caregivers that we talked about a minute ago who are taking care of children outside the system do not have that legal relationship with the child because of the fear of the system or possibly sometimes the inability to pay either a lawyer or to pay the fees to obtain custody and guardianship. Or they don't simply understand what their options are, what their legal options are to care for the child. The court is in a tenuous position of having to balance everything. I always say, boy, I'm glad I'm not a judge. It's a lot to balance. It's a lot to sort through. They need to balance what's best for the child, what's best for the family, and is this relative really what's best for the child? We're going to talk about notice in a few minutes, and the notice provisions of fostering connection, which I always say is one of the best pieces of legislation that's come out, because it says you want to avoid what we call the late arriving relative, and I'm sure you've all dealt with that. The relative who shows up at termination of parental rights and says, if I had known the child was in care, I would have come in from the beginning and taken care of the child. So now the judge has to sort of make a decision. Do I let the child stay with this foster family that they've known for so long, or do I try to establish the relationship with the relative? So we're going to talk about how notice and engagement of family will hopefully prevent that difficult decision at the end of the case, and hopefully all the decisions will be made at the beginning of the case. As well, the judge has to balance the laws and the policies and make sure everything's being followed. The most important thing we can do for our courts is make sure they have all the information. The courts cannot make a decision if they don't have all the information. And so making sure that the families are well informed and that the court has the information to proceed in the case. So we said fostering connections passed on October 7, 2008. It has been the most significant piece of legislation that's passed in a decade. There are several provisions of fostering connections, not all kinship, but these are the kinship provisions in fostering connections: notification, kinship guardianship assistance, family connection grants, licensing standards, and sibling placement. As we go through those provisions quickly, I'm going to tell you which are optional and which are mandatory. The thing about fostering connections is that some of the provisions are optional. The states don't need to opt into the program, but most of them are mandatory. So we'll go through and make sure that it's really clear right from the beginning as we go through the provisions which are mandatory and which are optional. Okay, so the notice requirement, which I just talked about a minute ago. What fostering connections said is that it is required, again, this is your clue that this is not optional, this is mandatory, required to use due diligence to identify and notify all adult relatives within 30 days of a child's removal. Okay, the only exception is for family or domestic violence. If there is believed to be family or domestic violence of that relative such that it could potentially be harmful for the child to be placed or for the relative to even know the child has come into care. The notice has to specify that the child has been removed or is about to be removed, explain the different options that the relative has to participate in care, describe what are the requirements to become a foster parent should they decide that they want to be a foster parent, also cover what are the other services and supports available if they don't want to become a foster parent but still want to care for the child, and describe the kinship guardianship assistance option if it's available, which in Nebraska it is. So that's the federal fostering connections. So then we take a look at what does Nebraska law look like? What does Nebraska policy look like? And what is your compliance with fostering connections? Overall, all of my research that I had done to prepare for today, looking at all of Nebraska's laws and policies, you're in excellent shape. I was really impressed with a lot of your policies with regard to family engagement and a lot of your laws with regard to compliance for fostering connections. However, what I will say is law and policy is fantastic if it's being implemented. It's only as good as the piece of paper it's written on if no one's following it. And that you all will know better than I will. I can stand up here, and I will, and tell you what your laws and policies say. But what I'd love to hear back is whether you're actually implementing these laws and policies. Is it actually happening on a day-to-day basis with regard to connecting with relatives? And so that's what I want to talk about. We're going to lay the framework, but then we're going to talk about engagement and how you actually have to make these laws and policies reality. Okay? But first, to do that, we'll lay the legal framework. So what your statute said, it follows the federal mandates pretty much, that you have to notify within 30 days, that it has to be in writing, which, by the way, the federal government did not require it to be in writing, but it is best practice, and your law does say it has to be written. And then it says that it has to be to any non-custodial parent, grandparents, adult siblings, aunts, uncles, cousins, and any relatives suggested by the child or the parent, except, again, the same exception that the federal government gave. But what I really like is that your law takes it a few steps further. Okay? It says you need to ask the child in an age-appropriate manner. I will talk to people who say there are no relatives for this child, and I'll say, well, did you ask the child? Because when you ask the child, you really get a wealth of information oftentimes. And so asking the child, who do you see for holidays? Who do you spend time with? Who have you ever lived with before? Will give you a whole host of relatives that maybe the parent simply forgot or didn't really want to mention to the agency. We all know that when a child's being removed, the parent's not exactly chatty. They don't want to sit down and give you their whole history and give you the names of the relatives. And frankly, a lot of them don't want the relatives to know what's going on with them. So the children, especially if approached in an age-appropriate manner, can really be a wealth of information. And I was very happy to see that that's not only best practice, it's what your statute requires. Additionally, the department needs to provide to the court within 30 days after removal all of the names and the relationship to everybody who's been contacted, how they've been contacted, and what was their response. You know, were they interested in having a relationship with the child? Were they maybe interested in being a placement for the child? So it was nice to see that you covered the federal law, you did what you needed to, but then the law went a step further. There we go. So your notice has all the same requirements of the federal law. It has to be, you know, tell them they've been removed, explain the options, et cetera, et cetera, et cetera. Pretty much everything that the federal law requires your notice to say. When looking at your policies, same mirror of your statute, but it talks about what are minimum efforts. At the minimum, you need to contact maternal and paternal grandparents, siblings, aunts, uncles, cousins, and other adult relatives suggested by the parent. And then the policy goes on to define diligent efforts. I always laugh because when I talk about the federal law, people will say, well, it says you have to use diligent efforts to notify a relative. And they'll say, well, does that mean all relatives? And I said, well, that's what the law says. The law says all relatives. And they say, well, we have 50 relatives. Do we have to notify them all? And I always joke and say, well, once you find a good one, you can stop. But that's not really true. You do have to notify all 50 relatives. If you've got the names of 50 relatives out of the country, out of the state, they all are required to receive notice. The federal government did not define what's due diligence. What do we need to do to make sure that we're notifying the correct breadth of relatives? But your policy says a diligent effort is a minimum asking the parent or the guardian, asking the child, and following up on leads provided by collateral contacts, and using the federal parent locator service. So your policy went on to say this is what we feel diligent efforts are, at the very least. Diligent efforts are the following steps and the following efforts that need to be made by the department. It has to be done in writing, sent by certified mail with return receipt requested. Do we get the sense this is being done? I see some shaking heads no, a few shaking heads no, most shaking heads no, then no. Okay, well, guess what? That is your policy, that is your statute. So after you walk out of here today, at the very least, you're going to start pushing that envelope. You're going to start making sure that that's being done. Because again, great to have that policy, great to have the statute. If it's not being done, it's pretty worthless. So you want to make sure it's being done, and we're going to talk about why that's so important later. Okay? Additionally, you have a program memo that came out that talked about these diligent efforts that I guess are not necessarily being done, to locate and engage. You're one of the only states that actually takes it to that next step and says, you know what, locating is fine, notifying is fine, but you must engage the relatives and determine if they are a potential placement resource or know of a potential placement resource. And I really like this because this is something that I always talk about next. The next bullet says, can the relative provide a supportive relationship for the child or the family? Not every relative is a placement resource. We know that. Not every relative can take a child into their home. However, if they know the family needs help, they can be supportive. They can assist the family. Mom needs a ride, or dad needs a ride to therapy. Maybe they can be the person to drive them if they have no other way. And I got to tell you, having worked in a residential placement, there is nothing worse than a child at the holiday time who doesn't have anybody to visit, who doesn't get any letters, never sees anybody. Okay? So maybe grandma lives in a senior-only housing, so she can't take the child. Or maybe the child has significant needs and needs to be in a residential placement. But that doesn't mean that that relative can't be connected to the child and provide support to the family. So that's another really important reason for notice. It's not just about finding a good placement for the child, it's making sure that the child is connected and has that connection to their family and has that support. And not just for the child, frankly, this is a tough time for the parents too. They need the support of their relatives. So it was nice to see that your policy actually said you want to explore placement, but you also want to explore that supportive relationship. And finally, maybe the relative can give you any family health history, especially if the child's about to be adopted or exit to guardianship, that you might find critical. We know sometimes the parents either aren't as forthcoming as they should be or frankly disappear. So the relatives are a good way to sort of trace that history. So how does Nebraska define relative? Again, when all of these laws came out by the federal government, the government said, we're not touching that with a 10-foot pole. You states, you define relative. It's up to you to decide how you want to define relatives. And so some states went very narrow, third degree of relationship, fourth degree, fifth degree. Others were pretty broad and included what we call fictive kin. Okay, so the only definition I found was in policy. I didn't really find one in statute. The only definition I found for Nebraska, and you can all tell me if I've missed something, is relative. The family is to be consulted about the persons they consider to be relatives. So when I was a law guardian, I used to ask the child sort of, who's important in your life? And they'd say, Uncle Boo Boo. Well, a little hard to find Uncle Boo Boo. You try to figure out, is he really an uncle? What's his real name? All of that. But the child thought of that person as an uncle. Does the family consider them an uncle? A lot of people have godparents that they are really close to. Other people have godparents they've never seen. But there are people that the family considers relative who maybe aren't blood relatives. Your definition allows for such flexibility. It says, in some situations, the family might include persons who are not related by blood or marriage. At a minimum, efforts must be made to notify, same list we talked about before, and when the child is Native American, the tribe's definition of relative must be followed. So, the policy definition of relative is broad. Your notice definition says at the minimum you have to notify, that list. But your policy definition says, look, we're going to think of relative and family in a broader sense. We're going to think of people who have a significant relationship to the child or to the family. It can be a child's coach, some mentor, a big brother, big sister program. Those all can be considered for the purposes of this memo, as far as I can read it anyway, a relative who can be considered for placement or who can be considered for some sort of ongoing relationship with the child. Any comments, questions so far about notice before we move on to the next one? Because I'm getting the sense that maybe it's not quite happening the way it should. So you really want to think about that because that is the first step. It is virtually impossible to engage a relative if you don't know who they are. So we'll talk about those steps later, but they need to receive the notice. Again, like I said, the notice prevents things like what we call the late arriving relative who comes later in the case and wants a relationship, and then you have to choose. Okay, so the next part of fostering connection is kinship guardianship assistance, KINGAP. Okay, and that is subsidized guardianship. For the first time ever, the federal government said we will pay for subsidized guardianship for children who exit care to guardians from the foster care system. This is an optional provision. Nebraska is one of 30 states that has taken that option. Okay, basically, for federal subsidized guardianship, the children needs to be 4E eligible. They will get Medicaid if they have receiving subsidized guardianship. They do not have to have special needs, unlike adoption assistance. They go until the child turns 18. In some states, they have opted for 21. The agreement remains in effect if the guardian moves to another state, recognizing that we are a mobile society and guardians may choose to move. And if the child was eligible for adoption assistance at the time they exited a guardianship, should the guardian later want to adopt, they can again apply and be eligible for adoption assistance. Okay, so kind of already covered some of this, but federal eligibility, they need to have lived with the relative for 6 consecutive months. The relative needs to be licensed. The child needs to be 4E eligible. They have to have a strong attachment. Reunification and adoption have to be ruled out. Under the Adoption and Safe Families Act, there was a hierarchy of what are our preferred permanency goals. And I'm sure most of you know this. The first one is reunification. You always try for reunification. The second one was adoption, because adoption, frankly, is more permanent than guardianship. Most guardianships in most states, the parent can come back in and petition for custody to be returned to them. Whereas adoption, that does not happen. And occasionally it's overturned, but most of the time adoption is more permanent than guardianship. So the agency needs to show to the court that this is in the best interest of the child, that we've already looked at adoption, and for whatever reason the child cannot be adopted or will not. Sometimes the child doesn't consent to adoption, and that we've done everything we can to try to reunify the child with the family, with the parents. Federal law requires if they're over the age of 14, they have to be consulted before it's finalized. And we'll look at Nebraska policy and law in a minute, but federal law says you have to at least talk to the child. It doesn't say consent, it says consulted. If you have one sibling that's eligible and another one that's not, if you're siblings and you're both going to guardianship, you're both eligible. So sort of bootstrapping on the siblings. So looking at what the states need to do, they need to amend their 4E plan. They have to do a match of state dollars. Sometimes they have to pass new legislation, not required, but some states did. And they have to make sure there's a written guardianship assistance agreement. So currently there are 30 states and 1 tribe who's taken this option, including Nebraska. Okay, and if for any reason you want to look at those, it's all at grandfamilies.org. We are tracking that. So now looking at Nebraska guardianship policies and laws, you do have what we call a tiered approach. You have the federal subsidized guardianship, but you also have state subsidized guardianship. The only significant difference for the child's purposes is that who's paying the subsidy, okay? And so the eligibility criteria is a little different. What your policy says that first you have to make sure that the child doesn't qualify for federal subsidized guardianship before you look at the state subsidized guardianship, which makes perfect sense. You want to use federal dollars. You don't want to use state dollars if you can. So first, they have to look and see, is there a reason why the child would not qualify for federal? And if that's the case, but they still want to go to subsidized guardianship, then they look at the state subsidized guardianship, okay? Your subsidized guardianship is set up in a way that it terminates on or before the child's 19th birthday, and the child under guardianship shall be a child for whom the guardianship would not be possible without the financial aid provided by the section. Okay, so those are 2 of the criteria. So looking at the way the law is set up and the regulations, basically it says this is a subsidy that allows a child to exit foster care to a guardian with a continuing subsidy, very much like adoption assistance. Child's eligible for the guardianship program if, 1, they're committed into the care and custody of the agency. Your state regulation was interesting because they sort of layered other issues onto the federal. They said that they have to have a documented behavioral, emotional, or mental disability. They can be a member of a sibling group of 3 or more, so that they can be placed together. So this is something that sort of bumps them up and allows for them to exit to subsidized guardianship. They have to have the strong attachment. They have to live with the guardian for 6 months. And again, the same as the federal. They have to make sure that they can't return home, and they have not attempted adoption. It doesn't say anything about 4E. So my understanding, and somebody maybe can correct me if I'm wrong, is if a child is not 4E eligible, my understanding is that they could qualify for your state subsidized guardianship. Yes, okay, great. So that would be an example of a child who, okay, we wanted to exit to subsidized guardianship, we looked, they weren't 4E eligible, okay, darn, we can't use the federal dollars, we'll use the state dollars. A lot of states, when they saw that requirement that the child be 4A eligible, said, wait, we want to offer it to all of our children. We don't want to offer it to just the 4A children. So most states who have taken this option have also provided for some sort of state option for those children who are not 4A eligible, including Nebraska. So they can't be adopted. Your regulation's a little different. It says if they're age 12 or older, or if under 12 and part of a sibling group, or attached to the proposed guardian and cannot be freed for adoption. So that's interesting. You sort of put a slight age limitation on your subsidized guardianship. A lot of people feel very strongly that young children should not exit to subsidized guardianship because they actually should exit to adoption for various reasons because it's a more permanent option. Your state has sort of capped it and said, look, child needs to be 12. However, if they're under 12 and they're part of a sibling group, it makes sense for them to go with their siblings to subsidized guardianship, or if they have an attachment to the proposed guardian and can't, for whatever reason, be freed for adoption. And the whatever reasons generally are the relative saying, I'm grandma. I don't want to terminate my child's rights. I want to be grandma. Okay, so I'm not willing to adopt. Or the child says, I still want my mom or dad in my life. So the child doesn't consent to adoption. So there's some of the reasons why, especially with a younger child, you would not look at adoption. So your law sort of sets an age limit as sort of a caution. Caution, let's try not to just jump to subsidized guardianship for younger children. Let's make sure it's really the best fit for that child. Okay. And it says the prospective guardian child can function effectively without department supervision. Basically, they can exit the foster care system and still be able to care safely for the child. A child's eligibility ends upon the 19th birthday when the child becomes emancipated or when the guardianship order is terminated for whatever reason, for example, death of a guardian. Further, when all efforts to reunify the child and the family have been exhausted and there's no advantage to the child pursuing termination or parental rights, legal guardianship is an appropriate permanency option according to your regulations. Okay, any questions about subsidized guardianship? It's a little bit complicated. Do we get the sense that you've got cases that are going to subsidized guardianship? I did not get a chance to look at your data. So I'm seeing, how many people have worked on a case where a child has exited to subsidized guardianship? Okay, that's good. That's a lot. Do we feel like it's a permanency option that most people are well educated and well informed about? And I say most people, I mean the courts, the attorneys, the caseworkers, and the relatives. Everybody's got to know about it. Everybody's got to understand what it means. Do we get a sense that's being done well? Seeing some, maybe, maybe not. Okay, so potentially another area of practice that you really want to look at. A lot of states, when they started rolling out this federal subsidized guardianship, did the big push of training, did a lot of training and did a lot of work with their state around understanding what subsidized guardianship is and understanding, frankly, the differences between subsidized guardianship and adoption. I think relatives especially need to understand that there is a difference between the two before they make a decision. We all know we can't really make a good decision if we are not well informed. Okay, so I am glad to see Nebraska has taken that federal option, and I believe in Nebraska you had subsidized guardianship prior to fostering connections, so this is not new. Prior to fostering connections, 38 states had subsidized guardianship, but they were state funded mostly. Some funded through TANF and waivers, but most were state funded. So those 38 states said, oh, federal option, federal dollars to pay for this, I'm there, 30 of them, I'm there. But we do have a few new states that have jumped on board too. Okay, family connection grants, oops. Fostering Connections allowed for $15 million annually for different programs. The programs being Kinship Navigator programs, intensive family finding, family group decision making, residential and family-based substance abuse treatment. They granted 24 grants in September of 2009 for 3 years of up to $1 million, and now there's a new granting cycle. Applications were due, and we haven't heard yet who's received these grants. Okay, sibling provisions. Fostering Connections requires, see the must, states must, so again, mandatory, not optional, make reasonable efforts to place siblings together in foster, kinship, and adoptive homes unless it's contrary to the safety or well-being of the child. Got to make efforts to keep siblings together. If they're not placed together, you have to document why they're not placed together and make reasonable efforts to provide frequent visitation or other ongoing contact. unless, again, it would be contrary to the welfare of the child. They encourage periodic assessment of the placement and visitation, and again have said to the states, you define relative. We'll leave that to you. They have, however, said in their what they call program instruction that frequent visitation is defined by at least monthly. Studies have shown that children who grow up with their siblings when they exit foster care do fare better. They do better when they have that connection. If you think about it, if a child is removed, they lose their parents, they lose their home, they often lose their school, although Fostering Connections tries to grapple with that issue and keep them in the same school, and they end up sometimes losing their siblings. They've pretty much lost all connections. So Fostering Connections, recognizing that that's important, said, we really need to try to keep the siblings together. People ask me all the time, okay, so I'm supposed to place with a relative, I'm supposed to keep siblings together, and I'm supposed to keep them in the same school under Fostering Connection. Which is more important? I really wish I had an answer to that. I mean, I being a kinship advocate, know what my answer is, but that's not necessarily the right answer. You do have to balance them all, and it is all on a case-by-case basis. If you can get the trifecta, as I call it, and you can get them with a relative, keep them with their siblings, and keep them in the same school district, to me, you've really achieved everything. You've done the best you can for a child who has to be removed. But it is sort of a balancing act of what is the best situation I can have for the child. And it really moves us away from the I've got a body, I've got a bed, the kid's going into the bed concept, and trying to get a good placement from the child from the beginning. So what do your laws and policies in Nebraska say? They define sibling to mean biological siblings and legal siblings. So that's half siblings and step siblings. Your statute mirrors Fostering Connections, saying reasonable efforts to place together, exactly the same as the federal. However, again, you went on one step further, which I really like in your statute. If you look at the last part, the state must provide prospective adoptive parents with information about the child's sibling and encourage them to plan for ongoing contact. So if the children are coming in at different times or not being adopted together, they have to give the information to the adoptive parent that there are siblings. A lot of times what we have is some siblings in care and some not in care. So making sure that someone who's adopting the child realizes that there are siblings and that they can foster that relationship. Again, it's a law, but hopefully it's something that's being done. So basically, the other thing that your law requires is a written visitation plan, which I think is incredibly important. Oftentimes you have written visitation plans for just the parents. What your statute says is that you need to have written visitation plans for parents, siblings, and other relatives or important people in the child's life. That is required by your regulations, that there be a visitation plan, not only have a visitation plan, but it be written visitation plan for everybody. And I think that's incredibly important. We go back to keeping the child connected to family. If you don't have any efforts being made to visit with that grandma who's in senior-only housing and can't take the child, and there's no visitation plan written, is that visitation going to actually happen? And I get it, I really do. Caseworkers are incredibly busy. And then it becomes down to, well, gee, does it have to be supervised? Because if it has to be supervised, that's even more manpower. Who's going to transport the child? I mean, it's logistically, it can be a nightmare. If you think about a child having visits with the siblings, having visits with the relatives, and having visits with the parents, it's a lot to coordinate. And so what I really do is I encourage people to think creatively. When do you usually see your siblings? Okay, they can go to each other's birthday parties. They can go to each other's, sports games. There are natural ways. It does not need to be in a room at the agency on Wednesdays from 3 to 4. Okay, maybe that's what you have to do for parents because there's a supervision issue. However, sibling visitation does not need to be supervised necessarily. It does not need to be done by the agency. You can say, hey, foster parent A and foster parent B, or relative A and relative B, you need to coordinate visitation. These kids need to be in contact with each other. They need to be emailing and calling and seeing each other. A more natural way to be connected with your siblings than having visitation that's attached to the parent's visitation. The other thing that you want to be cautious of is if for some reason the parent's visitation is being stopped, maybe the parent's showing up at a visit drunk or on drugs, you're not canceling sibling visits. I often see that the sibling visit at the same time as the parent visit. So if the parent visit gets canceled, so does the sibling visit. The law requires they have frequent contact. So making sure that visitation is happening. And again, you have a policy that basically mirrors the federal fostering connections. So, final piece of fostering connections, licensing. What fostering connections said was to make sure that you're having licensed relative foster homes. You're going to allow for states to waive non-safety related state licensing standards. This is nothing new. This came out a long time ago, that states have the ability to waive non-safety. Again, federal government not touching what's non-safety. I'd love to see a published list of what's a non-safety requirement, but they aren't going to do that. In Nebraska, you allow for what's called an approval study. So it's short of licensing, so the child can be placed with the caregiver prior to licensing if they meet the following criteria in a non-emergency situation. So someone has to visit the home, they have to run a background check on the family, they have to check references. Licensing waivers. So the only waiver that I could find in your laws was a waiver of the training requirements for relatives. All other requirements for licensed foster parents are the same, from what I could see. Oh, he's just getting louder. Everyone still hear me okay? Very good. So according to your policy manual, some of the training can be waived for relatives. Okay. Has anybody ever heard of that? Okay, good. I'm seeing some nodding. That's great. A lot of times what happens is the law says that they allow for waivers, but then you go somewhere and they say, oh, we didn't know we had waivers. We didn't know that you could use waivers. So I'm really happy to hear that here in Nebraska that sometimes training is waived for relatives. Maybe we want to look at the other standards and see if there's a possibility of looking at other waivers that might allow for more relatives to be licensed. But you do also have what I think is called approved placement, where they aren't necessarily licensed. So that's another good option to allow a child to be with a relative when they're in the custody of the agency. So relative placement preference. Federal law states that there is a preference for placement with a relative over a non-relative. Just simple statement. Nebraska says the same thing. They have sort of a hierarchy of how they would like the child placed, that there's a preference for relatives, first preference non-custodial parent, then an approved relative, then an approved home known to the child, etc. So that's all laid out in your regulations. Now, for Native American children, there is also a placement preference among the different, tribe preferences, and that's laid out for you here, and I'm not going to go through that. When granting legal guardianship, there again is another sort of preference laid out. One is relative to the child, one is foster parent with an existing relationship, and one is new foster parent. Same for adoption. You look at best interest of the child, look at a preference for an adult relative, and then you look at keeping the siblings together. So that's sort of the hierarchy that's set up in your Nebraska law. So now we're going to talk about engagement. Okay, so we've talked about this is your legal framework. Those are your laws that you have in place. Whether they're actually being implemented or not is somewhat questionable, but those are your laws and policies. Again, knowledge is power. You know it's out there. You now know that these are the policies. Maybe you knew before too, but pushing the envelope is always a good thing. Asking the questions. Why is the child not with a relative? If the child's not with a relative. Have the relatives been notified? What was their response? Are they having visitation with their siblings if they're not placed together? Are they having visitation with their relatives? These are all questions that should be asked, frankly, at every single hearing before the court, by everybody. If not the court, by the child's advocate. If not by the child's advocate, by the parent's advocate. And hopefully there's an answer to all of those questions that make sense. So, again, notice. We have to take it beyond notice. That's what we're going to talk about today, is engagement. Developing a strong policy framework to support engagement. I think you here in Nebraska have it. Honestly, we're going to go through it a little bit. You have good policy. You have a strong policy for family engagement. The pieces that I want to make sure that you have is sort of the court providing the oversight, which it's quite possible you already have that. That's the part I can't get from reading the books. So I'll ask the judges. Are these the questions you ask at your hearings? The judges still in the room? Judges pretending they're not. Are these questions that you ask about relative placement and about connections with relatives typically at your hearings? Yeah, okay, good. And if they weren't before today, hopefully they will be. Excellent. The other piece that's really, really important is documentation. When I train caseworkers and social workers, I tell them, look, you are probably doing great casework practice. But if you don't document it from a lawyer's perspective, you don't get credit for it. It's like you didn't do it. Okay? And I tell them, you win the lottery tomorrow and someone inherits your case file. They need to know why Aunt Betsy, who calls every day, has been ruled out, so that you don't go down the same road with Aunt Betsy. So documentation, incredibly important. What relatives have you contacted? What was the result? What background checks have been done on those relatives? Why is the child not placed with those relatives? Were the relatives unwilling to take the child, but now they come forward? What kind of visitation? Everything has to be documented in order to happen. So identify and locate parents and relatives early. It's an ongoing thing. I've been saying it the whole time. You have to find them in the beginning. You don't want them showing up at the end. Remember, if there is not a father that's involved, and I caution, I've been told, well, there is no father, and I tell them that that's biologically impossible. But making sure that you get to the paternal relatives too. Notice doesn't say only custodial parent relatives. It's the non-custodial, which is oftentimes the father, but it is the non-custodial relatives that need to be notified too. And it's possible they've not had a prior relationship with the child. That does not matter for notice purposes. And frankly, maybe you can introduce the child to a whole side of their family they didn't know, and a whole second support system for the child that they didn't know. So don't forget paternal relatives. Technology is great. We have all kinds of databases and searches and family finding and fantastic ways to find people these days. I mean, if you want to stay hidden, good luck. You really, really can't. Okay? But I do caution with technology, you want to double check, because some of the programs that are out there, I ran it for myself and I didn't know a lot of the people on the list that were supposedly my relatives. So you really do, technology is good, but it's not perfect. And again, documenting efforts and what's been done to contact the relatives and looking at their family history. And then we're going to talk about engagement. You need to first know who they are. Then you need to notify them, and then you need to engage them. And when you engage them, you have to make sure that you have an understanding of what is their commitment to the child. Perhaps it's just visitation and not placement. If it's placement, a lot of relatives will say, yes, I'll take the child, thinking it's going to be for a few weeks. They have to be told from the beginning, this is potentially a permanent placement. How do you feel about that? Looking at homes as foster adopt homes, thinking, look, we're going to work hard with the parents to try to reunify, but if it can't happen, I need to know where you stand with regard to permanency. Because what you really want to try to avoid is moving them from home to home to home. Okay. And again, avoiding the parent or relative who steps forward at the end. So here are a lot of sources of information. We already talked about the child, but the schools, the neighbors. I think it's really helpful if a parent attorney talks to the parent about, wouldn't you prefer your child be placed with someone they know than in a foster home? So making sure the parent's attorney take a big step in that direction to make sure they talk to their clients. Family group decision making is a really good way to bring the whole family together to say, what can we do to work with this family? What kind of creative way can we support the family? FPLS is the Federal Parent Locator Service, which is something that is, because of Fostering Connections, open to the child welfare system to look for people who you can't find. It's a little hard to access, but it's getting easier. And provider agencies, so your provider foster care agencies, mental health, et cetera, they're also a good source of information. Document and repeat efforts regularly, because circumstances change. Maybe at some point aunt can't take the child, but then she realizes, you know what, the child is staying in foster care. I didn't step forward because I really thought this was going to be temporary, or their circumstances change. You need to come back and talk to the relatives when circumstances change. So why engage the parents? By locating and engaging them early in the case, for the parents, the engagement is incredibly important. You can get more accurate and comprehensive assessment of the family's functioning. Sometimes you can rule out a reunification relatively quickly. We don't want to jump to that conclusion, but by engaging the parent and really trying to get them to plan for the child's future, you may find out it's not going to happen, and the parent might come on board and say, you know what, I know I can't do what I need to. Let's look at other options for my child. You want to identify prospective placement and supportive resources. Encourage the parents to participate. If you're writing a service plan with the family about what they need to do to get their child back, the first thing you need to do is ask them, what do you think you need to do to get your child back in your home safely? And that's a crucial piece of engagement that doesn't happen often. We often have people writing service plans and sticking them in the parent's face and saying, sign it. And I'm not saying that's what happens here, but it is what I see a lot, excuse me, is that the court tells the parent what they have to do, the agency tells the parent what they have to do, the parent's attorney tells them what they have to do, but no one asks the parent what they think they have to do. And it might be pretty eye-opening. They need the buy-in. They need to understand what is required of them, and they need not to be set up to fail. They need to be everything that is planned for reunification needs to be done in a planful way that can be achieved by the parent. So having a service plan with everything under the sun under it, and you know they're not going to do it all, is setting them up to fail. You need to engage them in the process, and it needs to be gradual. We also get the question oftentimes, if I have a substance abusing parent, and then often leads to homelessness, and they have no job, and so they need job training, and they need a house, and you get all of that on a service plan at the beginning. And the parent looks at it and says, okay, so I got to get clean, I got to get a house, I got to get a job, I have to do all these things, and it's overwhelming. And my answer is, you know what, take it in steps. Because the court order has to have all of that, because that's what's legally being required. But the service planning has to be, okay, you know what, if you're not clean from drugs, you're not going to be able to go on to that next step. So looking at it realistically and engaging them in the entire process. Also asking them if you can't care for your child, it's concurrent planning, if you can't plan for your child, who do you want to care for them? Let's say we can't return your child, and we hope we can, and we're working with you to do that. But if we can't, who would you want to care for your child? And getting them on board with what that concurrent plan is. All right. So how to engage, I sort of already talked about that. Focus on strengths, get the buy-in to get them to actively participate. Full disclosure is a principle of concurrent planning that I think is really, really important. Being truthful with them. I tell caseworkers all the time, you got to tell them, look, my job is to achieve permanency for your child. And I'm hoping that's with you. That's what I'm going to work on. But if not, I have to look for somebody else. So that they suddenly go, you told me you were working with me, and now you're filing a termination of parental rights petition? I don't understand, and they feel somewhat blindsided. But telling them from the beginning, if you don't do what you need to achieve permanency for your child and give them a safe home, I will have to look at somebody else. And tell it to them from the beginning. And people say, well, I can't have that conversation with them. Then I have no therapeutic relationship with them. And I think as a parent, I want to be told the truth. I want all the information up front. I want to be given the options to participate and engage. And the other thing I want to caution is remembering the child's attachment. In my idealistic youth, I thought all children who were abused and neglected would never want to be with their parent. And then I sat down and met my clients, and most of them wanted to go back to their parent. And I didn't understand it, but you know what? That's their parent. No matter what has happened in many cases, and I always knew the case was particularly horrendous when a child didn't want to go back to their parent. But acknowledging and recognizing that relationship is important to the child. So engaging relatives, we've got to really get to that right away. So we've already talked a lot about why the relationship with the relatives are important, decreasing the trauma, maintaining family relationships and history, culture, and all of that. Already covered that. So, and we pretty much covered this too. Why engage the relatives? That they can be a placement resource, they can be a supportive resource, they can be a permanency option. Okay, but something I didn't cover yet, but I want to talk about and point out, every year, many, many children age out of the foster care system, unfortunately. They are 18, 19, 20, 21, and they're leaving the foster care system. And don't you know, when you turn 18, you magically grow up, didn't we all? We never called our parents again for another question. We never came back to live with them when we didn't have a job, me. We all magically grew up at 18. Well, surprise, that does not happen. So the best thing I think we can do for the child, besides give them the coping skills to be independent, is to give them those connections. Make sure they have a relative who, frankly, when they lose their housing, they can crash on their couch and they won't be homeless. Is making sure they have those ongoing relationships with relatives before they age out of care. Really, really important, especially for older youth. So steps for meaningful engagement. Again, you have to know who they are, identify them. You have to locate them, you have to notify them, but you also have to engage them and establish those connections and make sure it's ongoing connections with the child and the relatives. So you've got your notice letters and your brochures and all of that, and that's great, but you've got to follow up. Again, I get a letter in the in the mail saying, you may be the lucky relative of such and such a child, and that child's coming to care. And I might not even know that child, but I might be related to that child. Or I see the agency, and frankly, I'm told by many clients that when they get a certified letter, they don't pick it up. They say it's going to be bad news. So I'm a little cautious about sending things certified. Frankly, I'd send it certified, but I'd send it regular mail too. There are a lot of people out there, you'd be surprised, who don't want a certified letter. They really think it's bringing bad news. So you got to make sure they're getting the letter, and then there's some sort of follow-up, and that they understand the options. Again, if they don't understand the options to be involved in the child's life, they're not going to opt to be involved because they don't know what they're allowed to do. Oh, the child's in foster care, what can I do? A lot. So making sure that that engagement piece is happening. And then you have to make sure that they're committed to the child, assessing their commitment level. I think I get these questions, okay, I've got 5 relatives and they all want the child, and I say, what a fantastic situation. I wish you had that for every single child. And they say, okay, that's great, but how do I choose between the 5? Well, I don't have the answer to that. That's hard. I mean, you really, and part of it is you have to look at who's committed to the child permanently. You don't want them bouncing between the 5 relatives. Who says, and it's best you can figure it out with your crystal ball, who is truly going to stay committed to this child? And not just say when they're a teenager, I'm giving them back to you, because we all know we'd like to give our teenagers away, I included. But someone who's truly committed to all those, to the children for their life. Background checks, incredibly important. And sometimes the child doesn't have a relationship with that relative, so you think, hey, I found this aunt that really wants you to come live with her. Isn't that great? And you think it's like the best thing ever, and you're excited, and the child just looks at you because they don't know who this person is. So making sure that someone's preparing the child for what they can expect, and preparing the aunt for the fact that they can't just run in and hug the child. A lot of these children really do have attachment issues. So making sure that someone is being cognizant of the fact that we may think it's the best thing, but the child may be a little hesitant. Being sensitive to needs and expectations and not building it up to be too much. So your engagement policy is really good as well. It recommends the court that there may be recommendations to the court about what has happened, what's in the best interest of the child. It talks about the importance of developing and maintaining a relationship between the child and the relative and the significant other, either for emotional support or placement. And this to me is excellent, to promote family self-sufficiency, because that's what we want to do. We don't want to be in these families' lives forever. And continuity for families and children. Consideration will be first given to assisting the family or the child build a support network. And that's what we've been talking about, with extended family members and friends identified by the family. So in order for the family to be self-sufficient, you want a support network. You caseworkers don't want to be the support network. I still get calls from clients. So you want to make sure you're building up a support network for these children and for the parents for the future. You have what's called an extended family information form that's being used by caseworkers to collect all the information about the relatives. Again, hopefully this form is being used. You have what's called, I think, a CFS specialist that's supposed to conduct this diligent search for relatives. Does anybody ever hear that term before, CFS specialist? Because that's what your policy says you have. Okay, good, some nods. Maybe they're in the audience. Anybody here a CFS specialist? No. Oh, one. Oh, good. See, they do exist. That's great. Again, I read these policies and I'm always curious if it's actually happening. Okay, so family engagement for older youth, we already talked about that. 49% of the youth who age out are homeless at some point over a 3-year period. My feeling is if they have a relative, they don't need to be homeless. Maybe the relative will only put them up for a few weeks, but that's a few weeks that they're not homeless. A lot of people will define permanency not just by a permanent plan, but by what connections the people have, what connections the child has as they age out. I already talked about the importance of older youth having a connection and developing a sense of belonging and identity. I think is really important. Everything we've talked about today about engagement of relatives becomes that much more critical for older youth. That's at the point where they're really trying to figure out who they are and who they're becoming. And I think a lot of positive will come out of keeping them connected to who they are connected to their family and to their history. Research has shown that the number one factor of success for a child who ages out of care is how many permanent connections they have for children. It's not necessarily their IL skills and can they balance a checkbook and can they, enter into a lease in the apartment, all important stuff. But the number one successful piece is how many permanent connections do they have? So I'm just going to leave you with the steps. Document the efforts. Ask everybody about who the child's connected to. Follow up with everybody. Engage the family. Have written visitation plans and establish significant relationships before the child ages out. Here are some resources for family engagement. I'm sorry I went really fast, but I had a lot to cover. If you're interested in finding out more about grandfamilies.org, you can obviously go to the website, but there's a flyer up here. If you're interested in our biannual conference, welcome to take a card. And thank you very much. Appreciate it.